Welcome to The Explainer. You know, U.S. employment law can feel, well, super complicated, right? So today, we're going to break it all down. We'll turn all that legal jargon into a clear, simple guide to your rights on the job.
I mean, who hasn't had a day at work where you just think, is this fair? It's a feeling a lot of us can relate to. And it turns out there's this huge, complex legal framework that's been built specifically to tackle that exact question.
And the whole philosophy behind this system, it really comes down to something that a huge majority, we're talking 78% of Americans agree on. The idea isn't to make sure we all finish the race in the same spot. Nope, it's not making sure everyone gets to start from the same line with a fair shot.
So here's our game plan for today. We'll start with what unfair discrimination actually is. Then we'll look at the laws that have your back and the path you can take to get justice. We'll do a couple of deep dives on sexual harassment and on age and disability. And we'll wrap up by talking about how fairness is really an ongoing process.
All right, first things first. Let's really get into it. Before we can even talk about your rights, we have to understand what the law means when it says unfair discrimination. Because, and this is key, it's not just about what feels unfair, it's about what is specifically legally not allowed.
Basically, it boils down to this. It's when big employment decisions, like who gets hired, fired, or promoted, are based on stuff that has absolutely nothing to do with the job itself. And legally speaking, this kind of bias really breaks down into two main types. Okay, so the first type is probably what pops in your head when you hear the word discrimination. It's the obvious stuff. It's intentional. The legal term for it is disparate treatment. And it's all about someone having a clear motive to treat a person or a group differently just because of who they are. But then there's the second type, and this one is way more subtle. It's actually unintentional. It's called adverse impact. This is where you have a rule or a standard that looks totally fair on the surface. It applies to everybody, but in practice, it ends up filtering out way more people from a particular group.
So that's the key difference, right? You've got unequal treatment, which is deliberate, like saying, I'm not hiring women for this job. Then you have adverse impact, which is a neutral-sounding rule, like a height requirement, that just happens to screen out way more women than men, even if it's not really necessary for the job.
Okay, so now we get the what, the two main kinds of illegal bias. So what's the how? How do we fight it? Let's take a look at the legal toolkit, the major laws that are on the books to protect you.
And you can really see the story unfold here over time. It started with the Equal Pay Act way back in 1963 and kept building. The Civil Rights Act, age discrimination, disabilities, all the way to family and medical leave in '93. This whole legal shield, it wasn't built overnight. It was put together piece by piece over decades as we figured out what needed protecting.
But the real big one, the absolute cornerstone of all of this, is Title VII of the Civil Rights Act of 1964. You could call it the bedrock. It's the law that says an employer can't discriminate based on these 5 core things: race, color, religion, sex, or national origin.
All right, so we've got the laws on the books. Great. But what happens if you actually think your rights have been violated? What do? Let's walk through the actual path to justice, step by step.
The whole system is really designed to start small and then escalate if it needs to. The first step is almost always informal. You try to work it out with your employer directly. If that goes nowhere, then you go to a government agency like the EEOC, and only if that doesn't work does it potentially end up in court.
And believe me, this isn't just some theoretical process. People use it a lot. Just look at 2021. The Equal Employment Opportunity Commission, that's the EEOC, they handled more than 61,000 individual complaints. That's a staggering number.
But here's where it gets really, really interesting. Look at the #1 claim on that chart. It's retaliation at a whopping 56%. It's not race, it's not sex, it's being punished for daring to complain in the first place. That in itself is illegal, and it just goes to show you how risky it can feel for someone to stand up for their rights.
Okay, keeping that idea of risk in mind, let's zoom in now on one of the most serious and frankly misunderstood types of discrimination out there: sexual harassment. You know, the actual behavior can be all sorts of things, but legally, the whole thing boils down to one single crucial word: unwelcome. If the behavior is unwelcome, and the person doing it either knows it is, or, and this is key, should have known, that it crosses the line into harassment. And the law sees this happening in two main ways. First, there's what's called quid pro quo. That's just Latin for this for that. It's the classic, you do this for me, I'll give you that promotion. The other is a hostile work environment. This isn't about one specific demand. It's when the jokes, comments, or actions are so pervasive and abusive that they just poison the entire atmosphere of the workplace.
This quote from a huge Supreme Court case in 1986 really nails it. The court made a game-changing decision. They said, it doesn't matter if someone went along with it. The only question that matters is, were the advances unwelcome, and were they bad enough to create an abusive environment? This was a massive deal because it blew the definition of harassment wide open beyond just that simple quid pro quo stuff.
So what's a company supposed to do about all this? Well, the best defense is a good offense. They have to be proactive. That means a clear, zero-tolerance policy that comes right from the top. It means having multiple, safe ways for people to report issues. It means actually investigating every single claim, quickly and confidentially. And it means training, not just once, but regularly.
All right, let's shift our spotlight now to a couple of other really important areas: age and disability discrimination.
So, the Age Discrimination in Employment Act, or ADEA, exists for a simple reason: to make sure people are judged on what they can do, not how old they are. It's all about fighting those unfair stereotypes about older workers, and it specifically kicks in to protect everyone age 40 and up. So if you think this has happened to you, how do you make a case? Well, there's usually a 4-part test. 1, you're over 40. 2, your work was good. 3, you were fired or demoted anyway. And 4, someone younger replaced you. If you can check all those boxes, the ball is then in the company's court to prove they had a legitimate reason that had nothing to do with age. Think about this for a second. 1 in 4 adults in the U.S. has a disability. 1 in 4. When you hear that, you immediately understand why the Americans with Disabilities Act, the ADA, is so incredibly important.
And the ADA is designed to protect what's called a qualified individual. So what does that mean? It just means a person who can do the main essential duties of a job. They might be able to do it just fine as is, or they might need what the law calls a reasonable accommodation from their employer to get it done.
And that idea of reasonable accommodation leads to some really concrete rules for companies. They have to provide those adjustments as long as it doesn't create an undue hardship. They have to make sure their buildings are accessible. They can't ask for a medical exam until after they've offered you a job. And maybe the biggest one of all, any medical information they have on you has to be kept under lock and key, totally separate and confidential.
So as we start to wrap up, it's really important to get this one thing. None of these laws are set in stone. They're not just old rules in a dusty book. They are part of a living, breathing conversation that we're all having as a society about what fairness even means. And that conversation is always changing.
Because at the end of the day, the core principle of all these laws is about equal opportunity for individuals. It's not about giving special treatment to one group over another. That's why what people call reverse discrimination, say discriminating against a white male applicant, is also illegal under the law. It is a really, really delicate balancing act. And you can see this conversation happening right now. You look at recent Supreme Court decisions about college admissions. Now, those don't apply directly to companies, but they're definitely sending a message. And that message seems to be focus on casting a wider net, on creating big, diverse pools of applicants, not on setting quotas or numerical targets.
And that really leaves us with the big question, doesn't it? It's the puzzle at the very heart of all employment law, and we're still trying to solve it. How do you make things fair and correct for historical wrongs done to entire groups while also making sure that every single person is treated as an equal individual? That's the challenge.